and LinkedIn, if you think those reflect different access to kind of ground truth information about qualifications, i.e. Facebook is relying on proxies for qualifications, while LinkedIn is relying on more granular data because of what people actually put on LinkedIn versus Facebook. And, there's been arguments and looking at how access to information about criminal backgrounds relates to kind of proxy discrimination based on race. And these are, I think, quite complicated because it kind of pits ideas about perhaps justice and fairness in awkward ways. But I'm wondering if you could talk a little bit about what you think that means here.
I think it's another question that is incredibly difficult to answer without additional information or without additional experiments, because I think our finding that Facebook's ad delivery is discriminatory tells us that it's discriminatory. Our finding of that LinkedIn's does not tell us which one it is either way, because there are also limitations in our methodology. Like in LinkedIn case, we had to come up with a workaround because the gender of recipients was not available to us. And just that workaround introduces uncertainty in our findings. So I really wish I could answer your question, but without additional tools, I cannot. I can only speculate, right? And I can only kind of increase the number of experiments and say, well, LinkedIn's information on the qualifications for the driver's job is pretty minimal because drivers are not really on LinkedIn. So maybe that's anecdotal evidence that that's not the reason in the difference of results. But that's just anecdotes and speculation. It's not proof.
Okay, I have one related question from Ada, which is in the case of the Domino's versus Instacart, whether the difference in gender distribution between, a question about the difference in gender distribution between the two jobs, and whether it was possible that there were further unobserved confounders that might explain the difference, such as differences in company policies, compensation, et cetera. So how can we ensure that we've accounted for all the relevant factors, which may not just be qualifications alone, I think is.
Right. So, so if Facebook is using differences in company compensations in deciding whether to show the ad to women or men, then that is not a legally protected excuse. What is happening here? That Domino's jobs are better compensated, so let's show Domino's job to men and not women. That is not legally protected excuse. So that's why we needed to control for the confounder of qualifications, and we don't really need control for other differences in the employers themselves, because we're really studying the role of Facebook ad delivery algorithm.
Good explanation. Okay, so first I want to thank, should I call you Sasha, Aleksandra, Alex? What? All
three work.
Thank you for that terrific talk. And I'm going to shift over into our panel directly without a break. I want to start by saying, while our panel was billed as interpretability in the law, I think our presentation suggests that a broader framing is appropriate. Perhaps interpretability, computation, and the law, which encompasses, I think, a much broader range of relationships between those terms, including but not limited to kind of the demands law places on systems, whether human or technical, that might require or at least be served by interpretability, demands the legal profession or the sphere of criminal law, criminal justice, for example, might place on machine learning systems because they view them as necessary for them to be safely, legitimately used within the system. Questions that law creates about the values that can or should be embedded interpretably within systems. and ways that computational methods can assist us in interpreting, interrogating, auditing systems in service of law and ideally justice. So I wanted to start with an opening question to all the panelists that references a paper by a colleague that I know Rebecca is working with, and I think both Sasha and Alice have probably interacted with before, which is the Rules for Computing and Social Change that Reddy Adebebe and co-authors wrote a few years ago for FACT. And in that paper, they offer 4 rules for computer science in social change. And they talk about computer science servicing as a diagnostic, right? A tool for helping us understand and measure social problems with greater precision and clarity. A formalizer, right? So that computing can shape how social problems are explicitly defined. So hopefully kind of clarifying and making a little bit more bright some of the problems and potential responses to them so that we can understand them. Computer science as a rebuttal, right? So it might illuminate some of the boundaries of what's possible through technical means, right? And I think that Rebecca has touched on some of like the tensions, right? And what the scientific method versus other methods of reasoning or interrogation might offer. And then synodosh, when it makes kind of long-standing social problems newly salient in the public eye, right? And I think a lot of the work that we've seen in journalism is in fact using kind of our fascination with machine learning to draw our attention in new and fresh ways to really problematic aspects of the use of technology to make decisions more broadly, right? It's not just about machine learning and AI. So I wanted to start by asking, to what extent are those rules useful in understanding the challenges surrounding interpretability of machine learning systems in your domain of research? Do those different things ring true to you? Or are there other ways that you or we might categorize the relationship between the legal and the technical to further your research or clarify kind of what is new about machine learning versus just computational systems in general in the particular context at play? And it's open. So any one of you, please take it away.
I could jump in and say, I'm so glad to know about this framework. So thank you for highlighting it. I wasn't aware of the paper before, and I'm excited to go read it. And just initially, yeah, absolutely. Specifically, the formalization factor seems really important to me. And I don't know whether the paper presents it as a good thing, but if so, I would push back and say, at least in my work, I see it as troubling in some circumstances. And so an example is that by focusing on technical solutions or technical definitions, we can shift attention away from other kinds of solutions to problems. And Aleksandra, I was just thinking during your talk when you were mentioning the commercial secrecy interests and how we could use technology to audit and still protect them. That's a formalization response, I think, if I understand the way Reddy and all are using the term. But it elides the question of whether these commercial secrecy interests are worth shielding from government mandated audits in the first place. So I get a little worried that the focus on the technical can draw attention away from changes in the law or legal rules that shouldn't exist in the first place.
Yeah, I think that's a beautiful, one of the reasons that I think these interdisciplinary conversations is so important. And so, I think I started my career over at starting the clinic at the law school, but very quickly had PhD students and master's students from computer science and engineering and the School of Information come over. And what was so valuable there is, we all have oh, I'm a lawyer, I'm a computer scientist, I'm a ML expert, let me take my tool and solve this problem. And that often forecloses the question of which of our tools, which of our expertise is the best way or the preferable way, or what are the trade-offs or long-term consequences of choosing particular solutions, given the kind of relative way in which they might advance different ideas about justice or fairness. Alex or Alice?
Yeah, so echoing a little bit of what Rebecca said, yeah, I also wasn't familiar with this framework beforehand, but I find it quite helpful to look at. And I think what I see as the utility of this is really clarifying a bit more in the broad scope of all different sorts of roles that computer science versus other fields can play. What are some of the very specific areas where we can target with more of a computing perspective? And I would hope that it's kind of focusing a little bit more on that subset, not at the exclusion of other approaches, since I think, by and large, there are the general trend with a lot of AI is to maybe go a little bit beyond what the capabilities should be in terms of social change, but hopefully in these more specific ways, AI can actually be used to address rather than amplify social problems. And particularly, I guess, with relation to my work, I think the diagnostic part is quite relevant when we think about ways to address bias in ML. And can we actually, for example, through this process, really diagnose some existing social issues and address them actively in a way that might not be possible with existing human systems. So, for example, when we talk, facial recognition is extremely controversial. I don't want to say that it should be, used necessarily, but we have a lot of issues, for example, with eyewitness testimony and human biases when it comes to identifying individuals. Facial recognition is not necessarily at the point where I would trust it for that purpose either. But if we did get to a world where it was at that point, then it could potentially, for example, benefit us in comparison to existing human options. I also think the rebuttal aspect is quite interesting, especially in relation to work that bridges legal and technical domains, because oftentimes I think a lot of the challenge in that bridge is the assumption that technical methods maybe can do a lot more than they actually can, or a misunderstanding of the ways in which they might fail. And so I think that's part of why it's really helpful to have these interdisciplinary conversations to really emphasize what those boundaries are. And so when we do try to legislate in the context of AI, it's done with better understanding of the actual capabilities.
Sasha?
I want to offer a counterpoint to Rebecca's statement on the formalizer part. Yes, sometimes the technical solutions can obscure whether we're even asking the right question. But I think sometimes the technical solution can bring a new perspective and a valuable perspective that wasn't available before. And that is actually perhaps new due to the capabilities of machine learning. And the example I'd like to give there is really the question of privacy and how, prior to, say, introduction of differential privacy, we were always thinking about privacy. Well, either this data set is privacy preserving or it's not privacy preserving. We removed PII, so we're good. And actually what that line of research, starting with the anonymization and then culminating in differential privacy, has shown is that really privacy is not this black and white. It's not enough to remove PII, because machine learning now brings new capabilities to make new connections that are not just encapsulated by PII, and really move this to a gradation, to a the privacy risk where it can vary on a certain scale, right? So that's a perspective that computing can bring as a formalizer that perhaps was not available before and perhaps would not be otherwise arrived at if we're just looking from the legal perspective.
And I do think computing has valuable contributions. Here we are at the Simons Institute for the Theory of Computing, and I think everybody in the room has a lot of important things to contribute. And I'll add on to what you're saying, which is that the absence of a formal solution is also something that legal actors can exploit for nefarious ends. So they could say, well, before differential privacy existed, there is no way to make this thing private. So therefore, don't punish me if it's transparent, for instance. And so you can come and provide alternatives, and we can use law to hold people to account based on those.
So I'm going to ask one more question, and then I'm going to see if Ben or Zach can tell us if there are questions in the room. I was wondering if you could each clarify the value of interpretability in your context of research. So, at a high level, do you view it as instrumental or intrinsic? Meaning, is it a means to an end, or is it an important end or value to be supported in itself? And if it's instrumental, do you see alternative ways to support the ends at issue? And I think, like, Alex, maybe you want to start, like, auditing and interpretability have multiple ways in which they might relate. But I think that they're both kind of tools that you are thinking about in relationship to serving other kinds of substantive values. So I'll let you start.
Sure. So I think my goal is really to understand the societal and individual impact of algorithms, right? And auditing is just one tool towards that goal. And of course, auditing is made much easier by transparency. It's made much easier by knowledge about the algorithms. And interpretability is one of the ways that can make it easier, because if the algorithm's outcome is interpretable, and if one can understand how one can change the inputs in order to change the outcome, then that makes it much easier to study what is the societal impact of these algorithms. I just, in like my domain of work, I haven't yet seen transparency efforts or interpretability efforts that actually shed light on the algorithms at play, perhaps because of the inherent tensions between the societal impacts and the business models. But I hope to remain optimistic that this will come, and also this will come thanks to the work of the group here today at Simons.
So this is a nice segue, I think, to kind of bring it over to Rebecca. So you were talking about a whole range of barriers, right? Privacy laws, contract laws, trade secrecy. To that, we could add the Computer Fraud and Abuse Act. We could add various barriers that also might be in FOIA that might limit access to the extent governments are using systems. And in the context, many years ago, I was part of a team with NSF funding that was looking at voting systems, right? And as you said, we needed the training materials. We needed access to the source code. We needed to do penetration testing. We had hardware people. Like the effort to kind of evaluate those systems required a whole range. The build environment could be important, the test environment, and contracts limited just about anything you wanted to do, right? You weren't even allowed to do, you could do logic and accuracy testing. Contractually, that was the only thing counties were allowed to do when they received machines, right? And there's been a lot of focus in the voting system, the relationship between standards, validation, certification versus what sorts of testing or access we might want on the back end, right? So source code repositories. And one of the things that I think you raised really as a framework for thinking about interpretability in the criminal justice context was the emphasis in an adversarial system, right? And the different tools that we're talking about, right? If we think about audits or explanation or interpretability, Sasha was proposing kind of platform assisted, the sort of auditing she does now, I would describe as adversarial auditing, right? And I'm wondering if you could talk a little bit about kind of these various ways in which you might advance serving your client's interests they're tangential to interpretability or trying to interpret, but not about the system telling you about itself. And whether or not there are like ones that you think are the most important to focus on in the context of that adversarial system. Like, do you want an interpretable system, or do you want to be able to interrogate everything rather than have interpretability per se?
Well, it's a really hard question. And I will say I'm a huge fan of the voting system auditing work that you did. And so that's been an inspiration. But the question I think you're asking is just super challenging. And it's if I understand it correctly, it's, what do criminal defendants want and why? And could a system that explains its own results in their kind of classic interpretability be useful? Yes. And could access to auditing or probing or something else be useful? Yes. So I'm going to provide a non-answer, but hopefully it'll be still useful, which is how I've been thinking about this, because I don't have the answer to your question. It's a really challenging question. So here's how I think about it. There's two levers in the adversary system. There's secrecy interests and there's access interests. And the questions that you asked, Deirdre, and that a lot of people focus on, understandably, are about access interests. Why do you want it? What do you want? What would ideally be what you would get? What's its use? What are you going to do with it? Why do you need it? And that might go up and down. It's maybe less useful. You don't need it that much, but it could be useful. It's relevant, but it's not necessary. And all of those debates will lay down on your subpoena rights or versus discovery, if it's constitutional, if it's Brady, if it gets you to compulsory process rights and rights to present a defense. They're fascinating, complicated issues over here. So I'm just trying to focus on this one and say what I want for criminal defendants is that they're not being blocked unnecessarily for stupid reasons. Stupid's a little bit blunt, but we just focus on the secrecy side. If there's a good reason to have secrecy, then maybe some of the access interests, like the source code or, I don't know what it would be less essential, and they won't defeat the good secrecy interest. But whereas maybe an audit with protective measures, the way Aleksandra is providing us, would be so essential that it would defeat even a good secrecy interest. But we don't know how to weigh those two conflicts unless we know whether the secrecy claims are legitimate or not. So I've been trying to focus over here, maybe because this one is just so hard to answer.
Great. Alice, any thoughts or comments?
I guess maybe just going to your original question. So for me, I usually think of interpretability as a means towards greater transparency and accountability. And I think part of what's kind of difficult in terms of defining the level of interpretability that is appropriate for these sorts of interests is, especially when we're talking about transparency, it's really a two-sided problem, not just in terms of, what we are able to say about a model's performance, but what the receiving party is able to understand based on that sort of explanation. And I think that creates a lot of challenges in this area, and is part of why historically a lot of explainability has been used more so for model debugging purposes rather than actually providing transparency for outside parties, since, of course, if you're the one developing the model and you have a lot of deep knowledge about it, then it's much easier for explainability or interpretability to directly serve that purpose. When we talk about interpretability or explainability or transparency more broadly for other parties, then it becomes much more complicated, since oftentimes that receiving entity might not have the technical knowledge to really consume the sort of explanation you might have available, or the actual answer that they need is quite different than what you can provide. And so to me, that's kind of the challenging bridge to try to address in this area if we want to actually allow interpretability to more directly serve these interests.
Deirdre, we have a question in the audience.
I have a question in the chat from the virtual audience that I'm going to read first, and then we'll go to the in-person audience. All right. So Mario asked if there was an independent agency that reviewed and validated ML systems used in the criminal justice system. And Rebecca, I don't know that we have time to talk about how evidence and technology come in generally, but I'll let you do maybe a nutshell.
Sure, totally.
Answer is no, and.
Yeah, there's no and. Well, and mainly our reliability thresholds are built into the adversary system on a case-by-case basis, as Deirdre was hinting at. There are some minor exceptions, not for machine learning systems specifically, but NIST, the National Institute for Standards and Technology, does do some reviews of the literature and has written some really important reports, the National Academy of Sciences as well, that have raised alarms about the validity of many forensic systems, not specifically machine learning, but machine learning is involved in some of those systems. And then oddly, the National Highway Traffic and Safety Administration audits breath test devices. Again, I don't think they have machine learning in them, but that's this like one-off agency that actually has a mandate to audit every breath test device that police are going to use to charge you with driving under the influence. And it's just curious that this is a criminal charge that is frequently brought against white privileged defendants, and lo and behold, there's a special agency to audit that tool, but not for anyone else.
Yeah, I thought it was amazing when I first started looking. I was like, breathalyzers, wow. Like,
gotta be really worried about those,
Yes. Zach.
Yes, hi. Thanks for all the great talk so far. So I have perhaps a bit a general question. So one thing that we are currently trying all around the world is we're trying to actually already draft legislation that is supposed to regulate artificial intelligence systems. For example, in the European Union, we're trying to write this Artificial Intelligence Act. And so one question that I've been wondering around, and I'm a computer scientist, is if someone would ask me, like, what should we write into this law? With all the knowledge that we have today about the technical properties of these systems and our potential to explain them, interpret them, and the audits that we have conducted so far, I'm still at the point where I would say, like, it's really hard to say, like, what should we write into these laws? And I would love to hear if you have any opinions on this in the panel.
I might start, even though I'm the moderator and not a panelist. And some of you may remember the total information awareness debacle, which then produced like these congressional statements about banning data mining. And I was kind of like, what kind of math don't you like? And right. And there's like a person like regulating AI to me is a little bit like regulating math or regulating a tool and for the most part, I think like the more sophisticated discussions about AI and machine learning and the need for different kinds of regulation are incredibly situated within domains of practice, right? So thinking about, for example, if we are going to use machine learning tools, predictive machine learning tools in the context of clinical treatment and care, right, in the healthcare setting, thinking about safety, efficacy, equity, right, reliability, the transference or reliance on systems that produce knowledge in ways that are distinct and different from the ways in which humans might reason from data. I think, that's really important if we're thinking about it in the context of self-driving cars, if we're thinking, but I think, it's not that I think the kind of regulate AI isn't providing useful ways to think about particular challenges that are presented by developments in machine learning or developments in automation. However, I think in order to really get into the weeds, you need to be in a domain. And so I think those sorts of conversations are much more profitable. And I think, Rebecca's work kind of speaks to some of that, right? Because different legal domains have different demands, and different kinds of expertise and values and modes of reasoning, and relationships to professionals and standards of care and adversarialism.
I don't want to jump in. I want my panelists to go first, but I just wanted to say, Deirdre, I'd love to hear more from you, not just as a moderator, but to join us as a panelist moving forward, please. But love to hear from others.
Well, I have a question. Really wonderful talks, all three of you. So my question is, I think it was Aleksandra's talk about assumption that even the platform supports the audit, that they can still use a different algorithm than what's being audited. So, because if there's no way of checking that part, or the auditing is just a very superficial exercise, how would you, does it make sense actually to still use the algorithm they gave the auditor and run some test cases to compare, they actually give the same and run on the real platform? That's the only way I can think of sitting here to check indirectly whether they're using the same algorithm.
I think there could be penalties in the law. So maybe in the legislation Zach was so contemplating for providing false information in these kinds of audits, right? Like there is a case with the Volkswagen emissions, right, where they provided false information and got severely penalized when it was discovered. So perhaps we can have a similar provision here where if you agree to audit, you have to provide the information, because it's just not possible to double check everything. Right? There has to be some other non-technical solution that is helping us trust what is happening in the audit.
That's good to know.
Yeah, computer security people, right? They talk about you can move insecurity around, but you can't eradicate it. And I think often technologists are very interested in not having to trust any party within a system. And you're always going to have to be are you trusting the auditor? Are you right? And I think the question is, what are the kind of assurances that we use to make sure that people are behaving in ways that reflect the outcomes that we're trying to assess? And you're going to have to trust somebody.
At least here, I'm trusting more the editor. Maybe it's a wrong assumption, but depends on who is the auditor. My other question is, like, can you guys compare at a high level how the US PATA Act law compare with the DSA from EU, who's supposed to be taking effect next year? Like, are these two laws quite similar or different?
I don't think I'm familiar with the US, which US law and which European law?
The Platform Accountability Act and the Digital Services Act. I'm not prepared to kind of give you a blow by blow. I think Sasha has focused some on the differences in auditing. I think one of the interesting things about the Digital Services Act is it requires companies to kind of audit to avoid systemic risks. And there's some really like, how do we think about like system level risks and monitoring for them? And I do think that there's like some of the concerns that have driven this interest in systemic risk, right? The proliferation of false information about elections or about COVID treatments, or, go on and on. Those are things that occur, I think, at kind of the infrastructural or ecosystem level. They're not even fully visible, even from the platform level. Not that platform monitoring and auditing can't be of value, but I think there's really interesting questions there about, yeah. So Sasha, you probably have a lot more to say about it.
I've only looked at the very specific part that, you know, identifies privacy and business interest as a challenge to the proposals in auditing. So I can't comment more broadly than that. Both identify it as a challenge that needs to be overcome, and both, to my computer scientist view, don't have a concrete solution of how to overcome it. The other difference is that the Digital Services Act is going to be implemented. PACA hasn't yet been debated in Congress, so it's not, even though I personally feel that it's in the very right direction, it's not clear to me whether it's going to be adopted.
I think that's a question of another question or a comment, but maybe it's like a comment with a invitation to push back if your perception is something different. Alice, you said that a lot of the sort of post hoc interpretability tools are currently relegated to this sort of more in this model debugging purpose. And the reason was because the stakeholders there are people who have this expert knowledge to really understand what it means. And I'm going to push back and say that I think it's relegated there, not because I think they also have no idea what it means, and no one knows if any of these things mean anything at all. And the best evidence is that we have nothing concrete to say about any of them. And the reason why it's relegated there is because the purpose they're serving there is one for which there is no standard. So it's sort of, they don't debug anything. What they do is they sort of serve a role that's sort of in the, science says given a hypothesis, how do you test it? It doesn't tell you anything about how you come up with a hypothesis. So I think the role they're serving there is someone looks at the picture, and if they get some idea about what would be an interest, oh, maybe the model's doing something, let me now conduct some kind of actually well-formed test. Who's to say what is a good or a bad source of inspiration? So I think that the reason why they're there is not because the recipient has specialized knowledge such that it means something to them. I think we equally there, as everywhere else, have no reason to believe that it means anything. But it's over there that the standard that you have to clear is somebody thinks it's a interesting source of inspiration. But also if they thought that like looking at the stars in the night was an interesting source of inspiration, they're sort of open to them because the bar is that low there. Did you have a different sense for what these tools provide, or do you?
Yeah, I guess I would say I don't think there's actually high standards anywhere necessarily. I mean, even if we look at, say, the EU proposed AI Act, which maybe has some of the strongest transparency requirements that we've seen, there's not a ton of clarity yet in terms of what exactly goes into a conformity assessment, and especially in terms of more detailed information about model performance, since there's certain information like some information about the data that you use to develop your model, and maybe like some accuracy numbers and such. But by and large, I think there's still a lot of lack of clarity of what would be appropriate to put into such an assessment, and then what to really do with that information in terms of, at what point is that sufficient versus not. And so, I mean, I wouldn't say that the bar is so much higher outside of folks who are trying to debug their own models. And also, I guess I would push back a little bit in the sense that on the point that interpretability or explainability methods currently are not useful at all for debugging. I think they're extremely limited and oftentimes can be used to, fool the people who actually are trying to use them to better understand their own models. But I think, they're better than nothing to some extent. If you're, for example, using some saliency maps to try to get some sense of where your model is focusing, that's better than maybe not using it at all, as long as you really understand the limitations of that kind of method and don't just take it as, okay, as long as my model is not looking at information that would disclose a sensitive attribute, thus it is fair. That sort of interpretation, I think, leads to folks overstating what these sorts of methods can do. But provided you really accept the very limited amount of information that can be derived from these methods, hopefully it can still provide some utility.
One of the interesting pieces of PATA, Oh, is there another question?
Yeah, I mean, this all connects back to my earlier question to Rebecca that you answered very well about the knowledge required from judges. I think it kind of now puts the emphasis on the expertise required, not from the judges, but from those who set the rules. I mean, sure. So but the legislators, those who set the regulations, what kind of expertise they have, and also in some sense, I mean, they trust us as the companies or whoever develops interpretability or fairness notions, they trust what we're giving them, but we tend to be overly optimistic or overly promising about the tools that we can provide. So like what Alice was just saying, I mean, if you use Lime or saliency map or whatever, it is very limited in what kind of interpretation it can give you, but the people who market it are not so upfront about describing the limitations, and the legislators or whoever makes these rules are happy to assume that there is a solution and not probe any further. So how do we make this whole pipeline of realizing what are the possibilities and the limitations of the tools, how do we make it go through to those that make the rules?
Well, one answer is, I have two answers. One is in the case-by-case adjudication context, if it's criminal or it's civil or if it's administrative, there's an advantage, which is A, adversarialism, and B, it's as applied. So one of the things that I get particularly worried about are the rule setting or the standard setting in general ex ante. Without having a back-end ability to contest and challenge and scrutinize as applied. So maybe you're right, a company, a developer overclaims, Lime, they say can do everything, it solves everything, we know exactly how these machine learning systems work, and it doesn't really. Well, once you get into deploying it in an individual case, if you empower actors in that case to expose the overclaiming, then you'll have a better chance of doing that, and you don't have to anticipate upfront every possible way it's going to fail. That might be another answer to Deirdre, your challenging question about whether interpretability is inherent value or is a instrumentalist value. Is it maybe it's a case-by-case analysis? But from the other perspective of the legislatures, I just want to throw out an idea. Yes, we have a huge problem that legislatures are at expertise deficits and resource deficits, and they're depending on very young staffers and to work in their offices, and as a result, they're kind of vulnerable to overclaiming and lobbying from industry. And yes, I acknowledge that, but I also want to just throw out maybe a provocateur idea, which is that the narrative that I frequently hear that lawmakers lack the expertise to regulate is actually politically powerful narrative to discredit regulation of technology. And so to say, well, technological change is so extraordinary and technological expertise is so challenging, yes, those things are true. But in fact, that's true for lots and lots and lots of areas that legislatures regulate all the time. So I just want us to be careful about who politically is served by the stories we tell. And I suspect it's deregulation advocates who like to talk about the lack of expertise in the legislature.
I just make a comment about interpretability versus the use of the illegal area. But I think one thing we want to differentiate is that it's not every interpretation method is trustworthy. So there's also another layer of auditing of interpretation method, are good, authentic or not for what situation. Right there, because line might be working with other outside information we know can trust it. But it could also introduce a further bias on top of the algorithm itself. And that brings up like the interpretation now for human consumption. Now human now can bring in their own biases. So in the end, like, is there something else we can calibrate against to, we hope like the algorithm will create human bias and human can correct the algorithm bias, but relative to what? I think that's gonna be a very hard question. How do we know there was like interpreting an algorithm wouldn't make it even worse because the human now bringing their own bias. Oh, I don't want to use this variable because even if legally it's okay, but somehow I know it's not causal, therefore I don't want it to be used. I don't know how to get out of that kind of corner. Any thoughts about how we might in the future get both better?
Yeah, I don't have any solutions to this, but I will just say I do think one of the big challenges in this space, which I think your question really highlights, is just how far away we are from the point of really being able to say very concretely what appropriate algorithmic audits would be, and to be able to really do that at scale. I think one hopeful thing would be, if we have enough transparency and interpretability, that maybe some, adversarial process might be able to surface relevant factors. And that way we could maybe not have to be as specific in terms of what exactly goes into any particular audit, and thus, have legislation that's a little bit more broad. I think, it might take a while, I guess, to quite get to that point where that adversarial process and we have, enough case law or prior decisions to really inform folks going forward. I think right now the big challenge that we see is, there's a lot of broadness in terms of what people are calling for, and it's very hard to say, how do we actually do that in practice? And the research also, I think, really illustrates that, and no one really has been able to say here is, best practices for exactly how you would do, algorithmic audits for these 5 models, and that's been approved by, some other entity. So I don't have any answers for how exactly we get there, except, maybe long-term with enough examples that have been adjudicated, that might give us some clarity. But at the moment, I think the formalism inherent in ML does create this huge challenge in terms of making audits at scale.
I think we can learn a lot from how we think about building and assessing systems in high stakes domains. So financial services, healthcare, transportation, right? Where we don't rely on interpretability. We don't rely just on kind of adversarial audits. We do everything from, specifications to validation and testing to adversarial testing to disaster analysis, which I think can be incredibly important. And I think that, there's a lot in listening to the presentations the past few days, I think one of the things that really came out is the variety of ways in which people in different domains are trying to build systems that use machine learning or trying to use ML methods in very sophisticated ways, depending upon the kind of goals, values, capacities, and assets they have in different areas, right? So people are using causal models and predictive models, and they're going back and forth between them. People are using access to different kinds of ground truth data in ways that help them understand systems better. People talked about, being kind of data poor as a constant problem and ways to navigate around that. And so I think that the same way that we see like this real sophistication in thinking about how to use in these domains, we need to bring that same level of sophistication in thinking about how we reflect values that are important to those domains using a whole range of tools that interpretability is like part of, but clearly not the entire set.
Great answer.
Do we have more questions? I think we have time for maybe 2 more from the room. And then I would also, of course, I asked each of the panelists to think about questions that they would like to ask of one another. And I would be happy to open it up for that as well.
We can progress to the skirmish among the panelists.
I don't know if we'll have a skirmish, but Alice, why don't you start us?
Thanks. So sorry, I should pull up my questions. If someone wants to go first, feel free to.
Sure, I'll ask my question to Rebecca. Rebecca, are you optimistic that kind of the challenges that you laid out can be overcome within a reasonable time period with existing tools? Or do you see a need for new tools, radically different thinking, some sort of very big event that facilitates change?
Yeah, great. I think that these problems can be reformed, at least improved in the immediate near future. And a lot of the things that I'm focused on are trying to make legal arguments and work with technologists to develop new tools that can change the salience or meaning or possibilities of legal arguments today, right now. So it's a call to action. Yes, we can change things for the better. We also need the grand visioners, but I'm not one of them. I'm a small visioner of immediately applicable, possibilities.
Thanks.
What about you?
Great to hear the optimism.
Yeah. Well, yeah, a little optimism, a little pessimism. I think we can do good. Maybe not fix everything, but a little bit of good right away. Yeah. What about from a technical perspective? Are you thinking you'll see the changes that you want to see in the near term or the long term?
I think only in the long term, unless there's a big event facilitating changes in the short term.
Alice, would you like
my questions? Yeah. So, Aleksandra, you talked a little bit about this already in your talk, but just maybe to build upon what you already presented. What do you think are the major properties of social media algorithms that should be covered in an outside audit? And what kinds of entities do you think are best situated in order to serve as auditors and evaluate those properties?
So I think from the social media algorithms, the questions that are really back to the social scientists and legal scholars, what do they think are the most important questions, right? Obviously, the question of discrimination, the question of polarization, the question of shaping opinions in the way that the person is not aware of come to mind, but I think it's up to the broader community to decide what are the most important questions. In terms of who is well positioned to be this kind of auditor, frankly, right now, nobody is really well positioned. Because the people who are doing this kind of work right now are journalists and researchers, and they have significant impediments to their work and limitations, including financial limitations. So I think there needs to be perhaps policy decision to create a new entity that would have the incentives, the legal permissions, and the financial means to do this kind of work in the independent manner where the results are publicly disseminated.
I think that's kind of an interesting, I didn't want to kind of get into the TSA and PATA, but one of the interesting aspects of PATA, right, is that it creates a mechanism to study social media companies whereby independent researchers can submit research proposals to NSF. And if those are approved, social media companies are supposed to provide the necessary information subject to security and privacy requirements. And companies that fail to comply could be subject to FTC enforcement and also potentially lose Section 230 immunity, which everybody seems to know about Section 230, so I won't talk about it a little bit. And it also provides some safe harbor protection for researchers. And I think it's interesting to think about, NSF is supposed to create process and guidelines and criteria, and what criteria makes sense, and who at NSF is going to do the job of creating those process and guidelines and criteria, and just which questions are good. I don't know. And I think the question of is it a new entity that does this, or is it using all of the existing research talent that exists and figuring out ways to kind of create structures that encourage or require different kinds of research to be supported, that platforms, and you could think about scaling this to other kinds, right? All of the technology used in the criminal justice system potentially, right? Would a similar model where if you're going to be used in the criminal justice system, you have to have the capacity to allow for academics, to independent researchers to get clearance to study what it is that you're doing and how these things function. And so it's an interesting way of not creating a specialized team, but benefiting from all the kinds of questions that researchers might think are worth asking. I do think that this runs in also to an interesting point that I really appreciate Sasha putting a pin in, whose questions would be asked then, right? If I see one more study about how much disinformation there is, I'm is that really the question we want to answer? And I think kind of social scientists, legal scholars might have different ideas about the kinds of questions that would help us design better systems or better understand problems than machine learning or CS researchers kind of operating on their own. And so thinking about what kind of criteria might guide that, because we, first come, first serve, we could have I don't know, there's only so much research that's probably going to be able to be supported.
I think somebody on Zoom has a question.
I'm not sure I'm seeing it. Oh, there it is. Great. This is from Kevin Stengel. he missed some of the talk, so if this was already discussed, he's sorry, but do you guys have any thoughts on how the US Census Bureau has published its own privacy audits in response to its legal duties to maintain privacy? For me, it's an interesting precedent for privacy-aware data analysis and research that could inform other auditing scenarios. And Kevin, are you talking in specifically about all of the various work that they've done around the implementation of differential privacy? I too, yeah. So I don't know whether or not all of you have been following this. I assume Sasha probably has, and I assume Alice and Rebecca, you're probably like, what? But one of the things that's very interesting is, right, so we've seen this handoff, right? Historically, census has used a range of statistical disclosure limitation techniques to meet their obligation to limit the availability for taxpayers to be, for citizens to be identified. And they realized, in part due to research by people in this community, and certainly in the differential privacy community, that the statistical disclosure limitation techniques they were using were not fit for purpose. And so they realized that in order to provide meaningful data, they needed to shift over to use differential privacy. And this has become kind of like an enormous political storm. And part of that, I think, is about, and they have used kind of every technique in the book to make information about their choices and what they're doing available. However, their constraints, like they can't make the noisy measurements available, which means that differential privacy experts can't actually figure out whether or not it's good privacy. And they can't make baseline data available for people to understand how much noise is being infused. And therefore, there's many people who don't trust that the noise is what they say it is. And so they have been enormously, like they've engaged in an enormous process to try to help people understand the choices that they're making. And in many ways, DP allows them to be much more transparent about the choices they're making than statistical disclosure limitations that they've used in the past, which rely on secrecy to avoid disclosures. And it's been really like, you know, the magnificence of a disaster, man. And there's litigation and I think it's truly fascinating and really underscores some of the complexities of trying to build both trustworthy and trusted systems that rely on algorithms that many people do not understand and implementations of technical definitions. So Sasha, to you.
I agree with what you said, teacher. And to the question, I would add, yes, it is a very interesting and very noble example of how one does its own privacy audits and how one is transparent about the limitations of current techniques and then uses those studies in order to explain why the new techniques are needed. And I personally think that those audits are very good motivation for why differential privacy is needed in the census. But I don't know if this can be a blueprint for other types of self-audits, because the US Census Bureau is not in the business of making money from violating people's privacy. And so they can improve the privacy of their systems potentially without business cost. There are other costs that Deidre talked about, but there's not a business cost. And I don't see the same kind of audits being done by entities who are in the business of making money from private data. And that can go to also other places like algorithmic fairness, right? If your business fundamentally is making money from discrimination, I don't know that you're going to be in a position to be making audits and making them publicly available about whether your systems are non-discriminatory and whether those audits without a third party involved, they're going to be trustworthy. I know.
Sorry to jump in, but I think we have to finish. We're 15 minutes and the lunch is outside for us.
Great.
But it has been a really fascinating discussion and talks. So maybe.
Thank you so much. This was a pleasure.
Thank you, Sasha, Alice, and Rebecca for joining. And thank you, Ben and Zach, for reminding me that you guys might want to eat.
Well, thank you. Let me just stand up with Zach to finish this workshop officially. So I really had a great time, but of course, we also the organizers. So that's probably we should have some objective evaluations later. But I'd like to thank the staff for their support, especially and Kalani, who is now here, who has been always supporting us throughout the whole process. And hope the discussions continue for the long-term visitors. And then Zach will probably have his comments.
Yeah. As also I like to, thank Ben for who's by far the more on top of everything than me, and a good mentor. So, and Shai and Ruth, who approached us, I think over 3 years ago.
And those are the other community members.
Yeah, other committee members of the workshop, absolutely, but also Shai for this, the very cluster existing, been keeping this torch alive for a tremendous amount of time. So, yeah.
Let me just mention the other workshop committee members. So this was planned 2 years ago. And with Zach and I as a co-chair, and we also have Deirdre on the committee, Hema, who couldn't make it, and David Madigan. So actually we kind of revamped everything, kind of restarted more recently, but they're also on the committee. So we should thank them as well. And lunch is outside. Hike will be led by Zach.
Where's Zach gonna hike?
Nice to meet you all.
Hope to see you back in,
Thank you.
hope to see Rebecca back, and I should get together with Deirdre.
So nice to see
And
you.
congratulations to Aleksandra for a new job, and Alice, I hope I see you again.